Well,
Thanks,
thank you,
Brian.
Brian, and thanks for the very generous introduction. I'm really honored to have Scott on the panel, and I'm honored, of course, to have you in my network because, you and I both have connections to Silicon Valley that go back decades. And as is very common, we have a lot of Hong Kong connections to Silicon Valley for a number of historical and technological reasons. And so it's been really, really great to collaborate with you on some of these cases. We've run a collaborative model. We want you to keep the client relationship. If you bring us into a case, of course, if you want us to be the lawyer, we'll be the lawyer. But if you want us to bring, you are a lawyer, you want to bring us into a relationship, that's what we do. We have templates for co-counsel agreements and so forth. So again, Scott, I think what Brian humbly alluded to, Scott teaches at the University of Miami, the international tax class. So, like, if you want the guy in this area today, you have him for the next 45 minutes or so. So get your questions in there because this is the guy who, and I'm the California guy. I teach that prep course for the specialist exam, so I could give you chapter and verse on the cases in California, but not international. And Scott is the guy for that. So between the two of us, we have inbound, outbound, cross-border, intra-U.S. border between Nevada and California. There's a lot of work that's done there. And so without further ado, I'm gonna let Scott take it away, and I'm gonna be the shill that will sit back in the audience and ask questions when Scott gets in superciliously over our heads.
And you'll take some chat inputs along the way, I think.
Yes, absolutely.
Peter's the gatekeeper there.
Absolutely. All right, well, it's nice to meet everyone. So what we're going to do first is just go through some high level basic concepts that are foundational to all the issues we're going to talk about and all the planning that's there. And the goal really behind all this is not necessarily to make you international tax experts, but to arm you with enough information to where when you see certain things or you deal with certain clients, you're able to, have the antennas go up and say, we might need to get someone in to help on these sorts of matters. I know enough to know there's an issue, right? So that's kind of the goal of what we're going to do today. And so, without further ado, what I want to start off with is, well, what is a U.S. income tax resident, a U.S. estate and gift tax resident, and how do we classify different types of entities? Because that's obviously the foundational piece. So in that regard, what is a U.S. income tax resident? And that's really a one of three people, right? You have U.S. citizens, you have what we call long-term permanent residents or green card holders, and then you have people who meet something called the substantial presence test. And what is that? That's a test where you look at the time spent physically in the US, and it's really two parts. So one, are they here 31 or more days in the current year? And then two, does the sum of a formula equal at least 183 days or more? And so the sum is, if we were going to calculate whether somebody meets this test for 2023, we would say, how many days have you been here in 2023? We count all those days. How many days in 2022? We count a third of those days. And then how many days in 2021? We count 1/6. We add them all together. If it's at least 183 or more, congratulations, you're a U.S. tax resident.
Income tax resident.
Income tax resident, exactly. So then we get into transfer tax, which means estate and gift tax. And that is a completely different test. That test basically looks to your domicile. And how do we define that? We look at individual and we say, did they have what we call like an overt act? Have they moved? Are they living here? And then do they have the intent to remain indefinitely? And that intent portion is a subjective portion. So this is the subjective part of the test, and it's different from income tax. So subjective things that we look at objective characteristics. Where is their houses? Where's their family? Where's their friends, organizations? Where's their valuables, their investments, all these types of things? Where do they keep their pets? Where do they keep their artwork? All these types of things help to figure out what was somebody's intent. Do they intend to remain in the US indefinitely? So the point of this slide is to show you, you can actually have someone that is an income tax resident, but not an estate tax resident, or they are neither. And you can have a mismatch basically in status between the two. So for example, where we see this commonly is now the US is importing a lot of C-suite executives that are coming here, working here on visa statuses. They're spending enough time to be an income tax resident, but they have no intent to remain here indefinitely. The plans to be here 5 years, 7 years, and then go back home. And so you can actually have different statuses, and the planning is very different depending upon your statuses. So important, just high level residency of an entity. It's as simple as, if you have a business entity, you look at where the entity is formed. If it's formed in the US, it's a US entity. It's formed outside the US, it's non-US entity. Different classification. So in the US, a corporation is what we call a C corporation. It's per se. LLCs, limited liability companies, are flexible. They could be anything. They could be flow through, partnership, disregarded. They could be a corporation. So you have an ability to make elections. And so that allows you to make an election with LLCs. That's why you see them. That's why they're so frequent. There's a set of regulations called check the box regulations. These are applicable, for example, in the LLC context and in the foreign context when you have non-US entities. So we have a list, and it's what we call a per se entity list, which means if you have an entity listed on this list, then it's per se and it's a corporation. You can't change the way it's classified. And if it's not on the list, now you have an option to change its classification. And that's done in different ways. But a common question that people miss is, well, what happens if you don't make an election and you're not on the list? Well, you have to figure out what its default classification is. And we determine that based on whether all the members have limited liability. If all the members have limited liability, then the default classification is a corporation. But you can make an election to treat it differently. And how do you do that? You go to form 8832, and that's a form that's filed. You normally file it within 75 days of the election you're trying to make. There's a provision or a rev proc or revenue procedure that allows you to go back as far as 3 years and 75 days if you meet certain requirements. But that's normally the form that gets filed and if you want to make an entity classification election. So what about other types of entities? What do you do? Being in Miami, we see a lot of Panamanian foundations and things of that. How do you treat that? And for US tax purposes, that's a confusing thing because it looks like a corporation, it has board of directors, but you also have, succession planning built into it. So it's kind of like a hybrid, right? And for our rules, you have to really dig in and make sure they're structured in a particular way so that it's either treated as a trust or an entity. And if it's an entity, you can make an entity classification election.
So Scott, if I
Yeah.
kind of just look back, we're dealing with families around the globe, and they have their entities, corporations, partnerships. And I think what you're saying with the election, we get to choose for U.S. tax how we're going to deal with it, classify, even though it might be called corporation in Hong Kong or wherever. We get to choose if it's not on that per se list. Okay.
That's exactly right. That's exactly right. So for a trust, what do we call as a trust? A trust is, has the purpose of protecting and conserving assets. It's, held for beneficiaries that benefit from the trust. But just because it's called a trust doesn't mean that it's actually a trust. You can have trusts in the US tax rules that's actually a business entity. It could be what we call an investment trust or a business trust, and that's taxed as an entity as well. So it's important to understand how an entity is classified so you can figure out, do we need to make an election and treat it differently if it is a business type entity, or if it's a trust, how do we figure out what that is? And so for trusts, we have a whole different set of rules. How do we figure out the residence of a trust? Well, there's two tests, and the US requires both these tests to be met if you want a US trust. And the two tests is what we call the court test and the control test. And so for the court test, pretty simple, you want it governed under US law. So for example, you can have a Nevada trust governed under Nevada law or California law or Delaware. That's going to meet the court test. So a US court has primary jurisdiction over the administration of the trust. But the next one is where a lot of people get tripped up, and you see a lot of people mess this up. It's called the control test. And really, all US persons need to have authority over the substantial decisions. And even just one non-US person, let's say, has the ability to appoint or remove the trustee, you have a foreign trust. So you can have a trust governed under Delaware law. You can have a bunch of US people controlling the powers, a US trustee, but you give a foreign person the power to remove and appoint a new trustee, foreign trust. So that's something that catches a lot of people off guard. It's a really important topic, and most estate planners even miss this themselves, right? And where you can even get caught in this is when you give that power to a successor person. Maybe it's not initially that person, but somebody passes away and a successor person has it. So this is a really, really important test. Now, what I want to jump into is income tax concepts, really basic. And basically, the importance of why we classify somebody is if somebody's a US tax resident, they're taxed on their worldwide income. So, for example, I had a person who came here on an E2 visa, an investor visa, to start a business. They spent 200 days in the current year, and they became an income tax resident and had to subject all their non-US income into the US tax net. Had no idea that they spent too many days and caused that situation to happen. So it's very, very important how you classify and whether you meet some of these tests. So US income tax person, taxed on worldwide income. Non-US person, you're only taxed on US source income. So there's different types of US source income. Some of that could be, traditional trade or business type income. But other of that could be, let's say, US source dividends. You own stock in Apple, and Apple pays you a dividend. You would be subject to tax on that income. And it's a gross tax. It's taxed on 30% withholding. It's a default withholding tax. Now, the benefit, like people from China that have an income tax treaty, that could be reduced. And under the treaty, if you make a treaty election, that could be reduced to, let's say, 10% under the treaty. But it's important to understand that any non-US person, what you're focused on is their US source income. I'm not going to go into the different types of source of income. I mean, there's whole different things, services, where the services are performed and other types of stuff like that. But just understand that you have to figure out where is that income sourced for non-US people. Now, I want to get into basic estate and gift tax concepts, understanding, again, classification from that domicile perspective. And for domicile, what's important to understand is that US citizens, again, taxed worldwide, right? US citizens and resident aliens taxed on worldwide assets. So right now our exemption's 12.92 million for US people. That's on your worldwide assets. If you're underneath that threshold, you're not going to pay estate tax. However, if you are a non-resident, you have a $60,000 exemption on your US assets. This is another one where people get caught. So you have a bunch of non-US people that will invest in US stock portfolios. They'll buy US real estate, and 60,000 is almost nothing. So somebody comes in, they buy $5 million of US stocks in the US stock portfolio. They pass away owning that US stock. You're going to be subject to a 40% tax on the value over 60,000. Same thing with US real estate or any other sort of US situs asset. So again, for the non-residents, we just have to now figure out what are considered US situs assets for estate and gift tax purposes. So what does that mean? Stock in a US corporation, that's a US asset for estate tax purposes. US real estate, another one. certain debts of US persons, certain types of, if you have any property like works of art that are physically present that you own that are in the United States, cars in the United States, those are US assets. But if you have, life insurance, non-US situs asset, certain bank deposits, the US wants to incentivize people to bank in the US. So certain types of bank deposits, they're not going to subject to that. But what's interesting is, and this is an important thing to point out, is there's a difference between the estate and gift tax situs rules. So for example, that same person that has $5 million of Apple stock or Google stock, that's a US situs asset for estate tax purposes. But if they then go and gift that stock, that is not a US situs asset for gift tax purposes. So they can actually gift that stock tax-free. So there's a disconnect between the estate tax situs rules and the gift tax situs rules. That's a really important point because that comes into a lot of planning we do with non-US people for estate tax purposes. All right, so now this is, Brian, were you saying something?
I was just saying, as a general rule, when you get into the international area, you have to abandon all your U.S. thinking because the international rules don't expand upon, they're just different across the board. And so don't use U.S. thinking when you're trying to transfer, move assets around, etc. Okay, go ahead.
Exactly. So now we're going to go into taxation of foreign trusts really quickly. And what I want to first do is just explain the difference of two types of trust for income tax purposes. You have grantor trust and non-grantor trust. What a grantor trust is, it's almost disregarded for U.S. income tax purposes. In other words, the grantor or the settlor, the person who formed and funded the trust, is subject to the tax on the trust income. Whereas in a non-grantor trust, the trust is itself the taxable entity, and it's semi-pass-through. What that means is, if the trust doesn't distribute out its income, the trust will pay the tax on the income. But if it distributes out the income to the beneficiary pays the tax, and the trust gets a deduction. But as you will see on this next slide, special rule for foreign grantors. The only way to have a grantor trust in the foreign setting is two ways. Either the trust has to be revocable, in other words, the settlor has to have the power to revest the assets in themselves, or the only permissible beneficiaries is the grantor and the grantor spouse during the grantor's lifetime. Without meeting one of those two rules, you can't have a grantor trust. So that's another one where people get tripped up. They want a grantor trust. They think they can use all these other powers and rules that we have in the US context. It doesn't work in the foreign grantor context. It's limited. So very important because we use foreign grantor trusts all the time. DNI, I don't want to get too deep down the rabbit hole in what this is, but when we're talking about non-grantor trusts, the reason this is important, it's a concept of whether the trust has the ability to distribute its net income. It's called distributable net income. And in a non-grantor trust setting, similar to what I talked about earlier, either the trust is paying the tax or the beneficiary is paying the tax. So what DNI stands for is, does the trust have this distributable net income to distribute out to the beneficiary so that the beneficiary pays the tax? And when you have a foreign trust, any DNI that's not distributed to a US beneficiary becomes UNI, undistributed net income. And undistributed net income is a bad thing to have for US beneficiaries. Why? Because when you have undistributed net income, you're effectively deferring tax. And when you're deferring tax for a US beneficiary, the US is not going to take kindly to that, and they're going to have a rule to make up for that. And what's the rule? They figure out whether you have something called an accumulation distribution, which means you are distributing undistributed net income. And when you distribute undistributed net income to a US beneficiary, what happens? Well, you're taxed at an interest rate under the throwback tax rule. So basically, there's a throwback tax that charges an interest charge to disincentivize people from deferring paying US income tax. I see this a lot, more than you would think. What ends up happening, more times than not, is somebody had local advice, they prepare a non-US based trust, a foreign trust, let's say governed in Guernsey or some other jurisdiction, and they have US kids and they make it irrevocable and they have themselves as beneficiaries, the US kids are beneficiaries, the whole family's beneficiaries, and these rules are going to come into play. And if you ever see this coming in an irrevocable trust type context, you need to make sure to reach out and we got to figure out how to fix it, because we have seen that when you defer long enough, the income that eventually comes out to the US beneficiaries completely gets wiped away. You pay 100% in US tax because the interest charge just keeps accumulating. And before you know it, you can wipe out the entire distribution to the US beneficiary in taxes. So it's an important thing to kind of catch. So I know I went through a lot. I'm gonna give you all a minute to ask any questions you want, and then we can go into some planning situations and go over some of the questions we have as to how these basic rules work in different contexts for clients that likely all of us deal with, or friends or family that we all tend to see who have an international footprint or a multi-jurisdictional footprint between US and non-US family members. Peter, you want to unmute?
I didn't know I was muted. Sorry, Scott. We have a question in the chat, tax considerations. So U.S. citizens are named as a beneficiary of a foreign will. So we'll put our foreign will in Hong Kong because this is the Hong Kong Bar Association, or the Hong Kong Association of Northern California. And they name, child who either was born in the U.S. and therefore they're a U.S. citizen, or they've been naturalized after getting their degree at Stanford, and they're geniuses and they're working in Silicon Valley, and mom and dad set it up so that child would be a remainder, a discretionary beneficiary under their will.
Yeah, so in that case, the question is going to be, what does the will say? And if the will creates what we call a testamentary trust after death, then we could have an issue, especially if that's going to be a foreign trust. So we may want to restructure the will. If the will is merely going to distribute assets out to the beneficiary outright, we get into situations with a foreign estate, and a foreign estate is taxed under these same rules like a foreign trust. And there's a lot of planning that can go into that, but it also depends on the type of assets. Are these US assets? Are these non-US assets? What are these companies? Are these real estate directly? When you get into these rules, there's a whole slew of basically anti-deferral rules for US persons, because US persons are taxed worldwide. The US does not want the US people to be able to defer their income tax. So the will itself is not problematic as of the day while they're alive, but you do have to make sure you're considering what's going to happen when they're not here, because there's going to probably need to be a lot of planning for that.
Yeah, to my issue per stirpes outright, you may be okay, but it depends, because if that Hong Kong individual is an NRNC, a non-resident, non-citizen, in one of the pieces of property they have is the condo they bought for their child while they were in college, you have a U.S. asset held by a NRNC, 60,000 exemption, U.S. estate tax.
Okay, so I think let's jump into some planning things we tend to see. And I know Brian's got a bunch of questions and things. So I'm gonna go to a simple one to start, just so everybody can see kind of something we see. And then we can go into some more complicated ones. So traditional setup, we'll see a foreign patriarch with $20 million of a US investment portfolio, which is invested in US stocks and securities. So right off the bat, you have a US estate tax exposure. We're dealing with one of these right now. Person didn't know about these rules. So you have an $8 million exposure right off the bat. So generally, what do we
minus
see?
the 60,000 exemption, Scott? It's a
Yes, which is
$7.94 million exposure.
exactly. So um, what we generally do in these situations, very common planning for this, is you'll see what's known as like a foreign grantor trust. So we'll draft the trust, let's say in South Dakota, Nevada, Delaware, and the trust will own a non-US corporation, could be a Hong Kong company, could be a Cyprus company. There's various different types of companies, Malta company, and that
Scott,
company,
you see a lot of BVI, right? I mean, being
ton of
there,
BVI,
which is the
ton of
British
BVI.
Virgin Islands. I don't know why we like that. Common law jurisdiction, Commonwealth. We understand it. We see it a lot. We know BVI trust companies. It's a check the box situation. So that's a kind of a
Correct.
common situation we see.
Correct. And so you will have this non-US corporation own the US stock portfolio, own the brokerage account, and that's usually a good situation. Where people get caught is when you have the US beneficiaries and what happens after death. What ends up happening is you have someone that knows enough to say, I want to block the estate tax. I know enough to put it into this structure. But then there's US beneficiaries that are going to inherit this. And there's a whole slew of anti-deferral rules for US people that run into this situation. So what can happen? You generate over 30 years appreciation built up in this non-US company, and a US person takes that over. US people are subject to rules under what we call the controlled foreign corporation rules, which means that after death, that entity becomes what we call a CFC, a controlled foreign corporation. And any income, any passive income that's earned jumps the company directly to that US person, and you don't get capital gains treatment. So you're being taxed at the highest rate, and you could pick up all the appreciation that's accumulated over 30 years, depending upon, when that asset's eventually sold. So that is a disastrous situation, and there's a lot of ways to plan around it. I've written articles about this. There's a whole slew of things that you can do, and it just depends upon who's going to inherit, how many US kids, how many non-US kids, what's the type of assets. Do we want a more complicated structure? There's a lot of different ways to do it. But one thing we've done is create a triangle of corporations so that at the end of the day, we can get this out and get a step up in basis that they wouldn't get as a result of holding a non-US company. So again, common structure, but doesn't always work depending upon who's inheriting and how you want to do it. There's other steps that would need to be considered. Another scenario, what happens if instead the foreign patriarch has 20 million of US real estate? Well, again, you have that same estate tax exposure. It's the same numbers. What type of structure do we generally see? Well, a lot of times we'll see a foreign grantor trust own some sort of foreign corporation that may own the US real estate directly, or they may have a US corporation underneath it that owns the US real estate directly. And there's a lot of income tax reasons why you may want to do that. But ultimately, again, what happens if you have US beneficiaries? You have to be very cognizant of who's going to inherit this, because they could inherit a CFC. So we may, upon death, restructure and do what we call a corporate reorganization that puts it in a situation that's going to be good or better for your US beneficiaries than would otherwise be for, let's say, non-US people. If all the people who inherit are non-US, then maybe that existing structure is good for them.
So Scott, this is salvageable at the
Yes.
death of the foreign person who's got the foreign grantor trust, so long as we act early before appreciation has taken place.
Yeah, and in the real estate context, even if appreciation's there, we can still do it. I mean, the beauty is there's a lot of little tricks that we can do on the corporate reorganization side to make it work. Because one thing that people have to remember is there's a distinction here between real estate and shares of US stock. Any person who is non-US that sells shares of Google today, and they could have millions of dollars of gain, does not pay tax on those sale of shares. Capital
US
gain
tax.
is sourced to the residence of the seller.
Mhm.
US real estate doesn't matter. It's 100% US source. So that's going to be always subject to US tax when that's sold. The question is, how do we restructure it to make it efficient? And there's a lot of tricks we can do there depending upon the family dynamic and the facts.
So,
So
Scott, as a basic concept, we want not to have the real estate owned by the NRNC. We want it to be owned by an entity, whether US or foreign, and maybe the NRNC has an interest in that entity. But as a general matter, that's roughly what you do in these situations, right?
you always want the non-US entity there to block the US estate tax. The US entity doesn't help. Now, you're subject to US estate tax on US corporate shares. So that's not good, but the non-US entity is helpful in that situation, and specifically a non-US corporation in particular.
Well, but you and I have talked about using a US corporation maybe as a trustee to avoid foreign trust status. So we may want a US corporation as part of the overall structure, but not as the ultimate beneficial owner.
Correct. It cannot own the US real estate unless the owner of that non-US corporation is of the US corporation is a non-US corporation. So again, we're talking about the actual asset itself, the US real estate. We want to figure out who the owner is, and does the non-US person at the end of the day own a US asset in their name? If they own non-US corporation shares, non-US asset, no problem.
So understand, Scott is teasing out the concept of a beneficial interest, like the owner, as he's saying, from the controller. The trustee may have no beneficial interest, but might nevertheless be a U.S. corporation. And there may be reasons for doing that.
Correct.
Hey, Scott, I've seen this situation happen. The foreign parent dies, and they're holding these companies, which create real problems when the U.S. person inherits those. So I guess it's a critical point to get immediate input, because you can make elections and retroactively change the status of some of those entities offshore that might, it's easier to inherit them. So quick action.
Correct.
Quick actions are really the key here when a foreign parent dies with substantial estate with U.S. beneficiaries.
Yeah, it's usually really important to make sure you get somebody on board if something happens like that, because a lot of times, and this is kind of to that point, we can do things to mitigate taxes or take action that basically allows a smooth transition or a smooth inheritance of assets. So for example, that's a perfect segue into our third scenario, which is, we've had people come to us. The foreign patriarch had a massive amount of US stocks. They died. They didn't have the planning. Now the brokerage is freezing the account, saying you owe US estate tax. And even if it's not subject to probate, meaning maybe it was held jointly with the spouse, or they named the spouse as a designated beneficiary in the brokerage account, the US brokerage firm is making sure that they're not going to be on the hook for that US estate tax by allowing the money to leave the US. So the account gets frozen, and they're saying you owe, let's say in this hypothetical, $6 million of estate tax. I've had people come with this exact situation. What can you do? Well, we've created what we call a post-death QDOT, a post-death qualified domestic trust, which basically provides a deferral of that US estate tax by putting it into a special type of trust. It almost allows for like the marital deduction, and that trust then allows the surviving spouse to inherit those assets. And then when the surviving spouse passes, they will pay the estate tax on that. And so one thing we may do is we may try and drain that trust over time to potentially reduce the estate tax at a later point. But at a minimum, you could potentially defer it until the second spouse's death. And that's something where, without talking to an international tax advisor, somebody would be like, well, it's too late. They died. You're subject to the estate tax. And that's not always the case. Sometimes actions can be taken. And we've done several of these where we've deferred the tax and even mitigated or minimized some of it. So
And this is one of the weird areas where there's a distinction between non-citizen and non-res. I mean, the surviving spouse could be a resident, a U.S. resident, but not a U.S. citizen. And if they're a resident, they have the $12.92 million exclusion amount, so that they're not stuck with that 60,000. So this is kind of a key point. So they can become a resident. If they became a citizen later on, that also works. Then the Q dot goes away
Correct.
entirely, and you could dissolve the Q dot. So understand there's a distinction not only with respect to the decedent, but with respect to the decedent spouse and what their characterization is.
Absolutely. Absolutely. And that's a great point, because again, there's a lot of things you can do on the planning side post-death. Even when you think, too little, too late, it's not always the case. There's a lot of action that we can do.
Hey,
So
just
this scenario,
sorry, quick
yeah,
question to Yanni. How are we doing on time? I know we had a late start, Yanni, and so uh, you're the official here. Keep going.
So Brian, since we are also receiving some questions from you and also from the attendees, we can
We'll push through the questions as far until what time?
we can do it until 5:05, about 8 minutes.
Okay, Scott, there.
all right. So scenario 4, another situation, you have the foreign patriarch that settles their irrevocable trust, benefit himself, spouse, and children. The trust owns foreign corporations and foreign mutual funds. Do you have a problem? And as we talked about when we were going through the mechanics, yes, is the answer, because what the US does is they provide what we call attribution rules to the US beneficiaries of these foreign entities. So not only do you have that UNI concept that we talked about, but you also have the controlled foreign corporation rules and the passive foreign investment company rules for non-US companies. And so the US kids could theoretically be subject to tax on the income of that controlled foreign corporation. And not only will it jump the company, it'll jump the trust directly to that US person as a result of the attribution rules. So this is something where we would dig in and say, okay, what is the terms of the trust? What can we do? Can we get the US kids out of this? We look at distribution history and all those types of things. Normally the kids haven't received a thing. It's normally always like a personal piggy bank for the foreign patriarch, or maybe even the foreign matriarch. And so we need to restructure and rejigger this in a way that's going to be efficient for US people. And again, what ends up happening is either a local lawyer provided a structure that makes sense under local law, and they didn't think to consult with the US side of things, where we would say, no, don't do that, or no, you need to restructure it this way. And we run into a problem, or it was set up before the kids ever even thought of becoming US. It's an old and cold structure, but the US kids came here, they got educated here, and then they made lives for themselves here and became, US citizens and green card holders and the whole nine. So this is a common situation you will see. And again, the idea here is just to point out all the situations that you could potentially see where that may arise, for you to kind of say, wait a second, I know the US's goal is to minimize deferral. If we have any sort of US presence, we need to take that into consideration in the succession of these assets. And this happens with high net worth foreign businesses. We have clients with family held companies that generate millions and billions of dollars a year, and they don't think of the consequences, that the fact that the kids came here, educated here, and now they're going to be subject to the US tax rules on those foreign businesses. So it's a common issue. We do this planning going both ways. Similar in the pre-immigration context, you're changing your status from a non-US person to a US person. So the planning is very different. And we set up all these structures in order to make it so that once you change that status, you are in a very good position, and frankly, a better position than the US people would be for who have been here their whole lives. So there's a lot of planning opportunity, but there's also a lot of gotcha rules. And that's what we're trying to help you spot is those gotcha rules. And the way to think about it when you're looking at a situation is just understand what the US was trying to do. People were playing games. They would use non-US companies, they would use non-US trusts to defer US taxation. So the US took a sledgehammer to a problem and they caught everybody else in that same problem when maybe people weren't trying to do the same thing, but they still have to contend with these rules.
Scott, how frequently do you see the IRS cracking down on mistakes that have been made? I mean, obviously, on the reporting side and on the planning side, we're not often we're looking for solutions to problems. We're not defending against the notice of examination or the liens and so forth. But in terms of your practice, how much of that is defense of action taken by taxing authorities going after people who have stepped on the landmines?
Yeah, I mean, we do a lot of that. Where we come into play a lot of times is we obviously do the defense side, but there's a lot of opportunities and plans where we can basically get off that landmine without getting crushed by US taxes. So I do a lot of cleanup of bad structures and bad things to get people into the right position. Obviously, sometimes there may be a tax cost to do that, but it's way less than what somebody would ultimately be subject to if the IRS ultimately and the structure persisted for a long enough period of time where, again, I've seen situations where people basically hand everything over to the government because of bad planning. So
the landmine blew up. So they stepped on it, they heard the click, and they ignored it. And when they stepped off, they blew off. They blew up. But if you step on it and you hear the click, you have a chance.
There may be still things we can do.
There may be a chance.
That's why we always get called, and hopefully on the front end, right? If you do it right on the front end, if you're thinking about these things, for any advisor that has non-US clients, your clients are going to greatly appreciate your services by being able to spot these things. Obviously, they're not expecting you to be an expert, but if you can get them in the hands of the right people, now they're like, you know what, this is a person that's thinking ahead. They're thinking about all my issues that I have to think about. But for them, I wouldn't have even known these things existed. So it's a really good thing from an advisor standpoint too.
Hey, Scott, I have a Hong Kong situation which you can't solve with the time we have, but you could maybe throw out a comment as to how people. So this individual, the parents, the father died in Hong Kong, and the U.S. individual was 60, 65. Anyway, he inherits quite a bit of stock, and that was paying substantial dividends. The monies never came back. They all stayed in Hong Kong. So on the disclosure side, this has caught a lot of people. And when you're looking back several years, I'll just throw it to you as maybe throw out a caution. This is really one of the bigger problems with U.S. Children, relatives, where they come into foreign money or foreign assets. Yeah, go ahead.
Yeah. So there's a bunch of forms that have to be filed for the U.S. people. Sometimes, there's a tax impact. Sometimes it's merely just reporting. And the penalties are really, really stiff. And again, the policy behind that is that the U.S. wants to know about it. They'd rather you not pay the tax than not tell them about the assets and the tax. So I've seen tens of millions of dollars of penalties just for reporting, not even for $1 of tax due. And there's programs in place. We enter a lot of them. There's streamlines, there's delinquent filings. There's all these things we can do to mitigate that penalty exposure. And frankly, a lot of times we get completely out of penalties or massively reduced where either we've had tens of millions and gotten it down to zero, or have gotten it down to a fraction of it. But that is a common situation. It's not just about actual income tax and paying tax or estate tax. It's also about reporting for US people. And those forms have hefty penalties.
You think you're falling on your sword, and all it is a nail clipper, because you're ready. You're prepared and you're armed on your side by saying, look, U.S., I didn't intend to defraud you. Here's what I did. There was no ulterior motive in terms of, reducing or deferring or delaying tax. Help me. And so there are these various voluntary disclosure programs that pop up from time to time, but there's also just, what Scott is describing, the transparency of the transaction can often get you from sword to nail clipper.
And when you see this in the compliance, if you happen to be audited by the IRS, almost all audits, right at the top, they ask, are there any foreign income amounts? Are there any foreign assets? And if you answer, you can get some forgiveness if you do it in advance. But if you're in the middle of an audit and don't truthfully deal with those questions, you have a bigger problem. So if you find someone in that position, they really need some counsel as to the
That's been our experience, yeah.